Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. The blockchain company Ripple and the Securities and Exchange Commission, SEC, seem to be nearing the end of their legal battle, according to a growing consensus in the cryptocurrency world. The case's resolution is widely anticipated to affect the future course of crypto market regulation, particularly with regard to securities categorization. As of March 27, a tweet from pro-Ripple attorney John Deaton predicted that a decision will be issued by the court within the next several weeks. If not this week, Deaton claims there is nothing to lose for XRP even if the SEC prevails since the coin offers the best risk-reward. But he said that if Ripple prevails, the fact that XRP is not a security would be established, and the token's value will rise. According to Fox Business, attorneys involved in the case have hinted that the legal conflict might terminate in the next days, thus increasing the likelihood of the summary judgment date. Deaton has encouraged the crypto community to see the lawsuit as an assault on the whole digital asset market and not just a Ripple problem, since he expects the contentious Heinemann speech emails will be opened on the basis of being judicial records. On March 23, defense attorney James Phelan tweeted that the SEC had sent its answer to the defendants in Ripple's letters requesting permission to rely on Bittner and Voyager as additional authority. According to the SEC's reaction, the letter included random thoughts, excerpts from the judge's concurring judgment in the Bittner case, and an order confirming the bankruptcy plan in the Voyager case. However, the regulator said that the extracts do not give any grounds to reject the SEC's move for summary judgment, despite the defendants' claims that they bolster their fair notice position. The SEC's answer to the Bittner case raises some fair concerns, Ripple supporter and lawyer Jeremy Hogan argues. But the regulator's effort to argue against the Voyager judge's finding on the perceived uncertainties of the crypto realm is smirkable. The answer, he said, renders the Bittner judgment moot, but the Voyager judge's judgment is still in effect for Ripple. Both sides are convinced they will prevail in court, so a settlement is a significant development. Bill Morgan, an attorney from Australia, said that all chance of a settlement was eliminated after seeing the cease's response letter. Brad Garlinghouse, the CEO of Ripple Labs, has attacked the chairman of the U.S., Gary Gensler of the Securities and Exchange Commission, SEC, for determining whether crypto tokens are securities. On Thursday, Garlinghouse tweeted, "It defies logic for the SEC chair to say that he determines what constitutes a security, rather than the statute from which his agency obtains its authority. It is past time for elected authorities in the United States to take notice." Why would you ever want to offer clarity about what's in or out when you act like an authoritarian overseeing a $2 2-cents be bloated agency? When there is no clear jurisdiction, uncertainty masquerades as authority, Garlinghouse said. The Ripple executive made the statement in response to Gensler's claim that current securities laws cover most of the activity that's going on in the crypto markets. Gensler was quoted as saying, "If Congress were to act, though I don't think we need these authorities not to undermine inadvertently through definitions of what's in or out, or in essence, allowing for conflicts that we don't allow. Several of the legislative vehicles, in my opinion, would weaken the securities remit if they were implemented." Since December 2020, when the SEC filed a complaint against Ripple, Garlinghouse, and co-founder Chris Larsen, the business has been involved in a legal battle with the securities regulator. The SEC declared XRP to be a security, although Ripple and Garlinghouse have continually denied this. Gensler has underlined the need of Bitcoin exchanges and lending platforms coming in to discuss how to comply with the SEC on multiple occasions. Garlinghouse, on the other hand, has accused the CC of engaging with crypto businesses simply to generate leads for its enforcement division. There have also been persistent accusations that the SEC lacks clear regulatory rules, making it difficult for crypto firms to assure compliance. The SEC has issued a Wells notice to the Nasdaq-listed cryptocurrency exchange Coinbase investigating alleged securities law breaches. In its reaction, the business said the SEC will not allow crypto companies come in and register. We tried. However, Gensler has consistently stated that, with the exception of Bitcoin, all crypto tokens are considered securities. The excitement around the result of the Ripple versus SEC litigation has reached fever pitch. Several members of the XRP community had counted on pro-XRP lawyer James K. Filon's forecast that Judge Annalisa Torres' judgment would arrive before the end of March. Unfortunately, his prognosis did not come true, leaving XRP investors perplexed. With many XRP fans wondering why Judge Torres didn't rule yesterday, crypto law founding attorney John Deaton identified the few insiders who may know the precise date of the judgment. According to Deaton, only Judge Torres' staff and the court clerk would be aware of the Ripple V's SEC judgment date. The only individuals who will know before the judge publicly publishes her verdict are her staff and any clerks who assisted her with research or decision-making, Deaton added. His most recent statement is in reaction to XRP aficionados who think Ripple and SEC executives will be aware of the date. It's worth noting that Deaton's statement came only hours after he anticipated that Judge Torres' decision may take up to 60 days. Notably, numerous XRP supporters were disappointed when Judge Torres did not make a judgment yesterday, March 31, as Filon projected. In response to a remark on the matter, Deaton explained that the deadline for Judge Torres to grant summary judgment was not yesterday. He indicated that Judge Torres might rule within the hour or opt to disclose the decision during the following 2 months. According to Deaton's past cases, Judge Torres normally gives summary judgment a few months after evaluating Daubert's motions. It is worth noting that Deaton is heavily engaged in the litigation, acting as an amicus curiae for members of the XRP community. Friend of the court, Deaton expects that, as amici curiae, Judge Torres will rule in favor of XRP holders by finding that the coin's secondary market transactions do not constitute a security. Deaton listed 4 potential litigation outcomes that might benefit XRP investors yesterday. Deaton believes that Judge Torres will decide that XRP secondary market transactions are not securities in all 4 scenarios. But if Judge Torres awards a summary judgment in favor of the SEC and fails to remark on XRP, Deaton said he would try to get the court to define the crypto asset, as he did in the Learbry case.